Absolutely. These mechanics are things that are both used against us and can be used as a strength. And it's why when you begin down this road, there are a number of groups very, very quick to laugh and belittle and deride this. But let's add to the proof of this, because the proof is overwhelming. Let's talk about the instrument that is used to convey property. Now, when I want to convey property, I don't use a normal contract. I need to use a deed.
Yes.
Yes?
Uh-huh.
Now, what makes a deed so special, and why does a deed need to be notarized or needs to be witnessed by someone in an office, in an ecclesiastical office, such as a notary?
I don't know that.
If property is something that ultimately comes from the divine, and that everything cascades from rights of use down, doesn't it make sense that any movement of that property is itself a sacred act, an ecclesiastical act?
If we take the premise that the divine is the only true ownership of everything, and we're just using it, so if we're going to use it for a while with a deed, purchase it, then it is a divine act. Is that what you're saying?
And that's the secret of deeds that they don't want you to know.
That's the secret, because we don't know that they're a divine act when we sign this paper or whatever. Okay. So take us forward.
It's why when people want to reclaim their property and they make a claim of right, that document, unless it is written correctly and in this knowledge, may not be ecclesiastical. So it is not a true deed. And if it's not a true deed, the system will not recognise it. Well, they won't recognise it normally if you try and do it outside of, but they will argue ultimately that it's not valid. They won't tell you why it's not valid, but it's not valid because it is not an ecclesiastical instrument.
Who will tell you it's not valid? In other words,
the cleric.
Oh, in other words, the one that we sign and we didn't know that it was a divine instrument, they say that it's not valid because it's not valid.
Correct.
Huh. And so we could learn how to maybe do a correct one or ecclesiastical one.
Well, this is the central issue. Our ignorance of the origin of the office, our ignorance of the origin and nature of property, our ignorance in the origin of the law and the private law of the private bar guild, of the private courts, all works against us, because that ignorance means that if we ever face a court, firstly, we don't even know what the word court means. We're told that it comes from the word cohort, or an outside space, as opposed to the word courtio, C-A-U-T-I-O, which means something totally different. It means to bond, to bail, and to trade in surety. It's an exchange. If we are ignorant, then the only person in a court that really knows what's going on, it's going to be the judge. And therefore, we will be, if we challenge, we will very quickly be discovered as incompetent. And that's exactly what they want us to be. They want us to remain incompetent in law.
If we challenge the judge who's really in charge of the court, or if we challenge another person?
If we challenge any aspect of the process, the charge, the fact that they're going to assign our home to a bank, or our car to a finance company, or take our children from us, our ignorance and then our anger, because when one is ignorant and really doesn't know what's going on, but does know that you're about to lose your children, one gets angry. So they use our anger and our ignorance against us every time.
Because if we challenge anything in this court, why do we automatically lose?
We lose because we don't even understand the power of our withdrawing our consent.
Withdrawing
we don't understand that our oath is the thing that they need to make what they do lawful. We don't even understand that we can even stand and say, when they give us a choice of nothing, take one poison or take another poison, that we will comply, but our compliance does not consent. That if we remain in honour, and if we even have an essential knowledge, then there almost isn't a single charge or court case or suit they put against us that ultimately can be successful. Because when they put us in their courts, they are making money. It is a money-making business.
So if a judge asks one if they plead guilty or not guilty, that's like picking two poisons.
Well, it does appear, but a plea, we talk about, again, things that originate from a time much earlier. What they don't tell you is that when you go to a court, you're dealing with form of law like a cake. So there's a base that comes from Anglo-Saxon, there's a middle there that comes from common law, and there's a surface at the top of it that comes from commercial law since the 30s. But the base of it is that all law is oral, all law is vocal, and that our oath is our bond. So when you plead, it's a tradition that comes from Anglo-Saxon where you're effectively ordering the court, you're contracting with the court, after the presumption that you have agreed, or that jurisdiction in three forms of personal, territorial, and subject matter have been concluded. That is, what is your name? Franco Collins. Well, then they claim personal jurisdiction because they have the rolls from birth, and therefore if you're on the rolls, you are a voluntary slave.
Or if you have
then
a birth
they say,
certificate.
where do you live? So I live here. I live in Dallas, or I live somewhere. They've got you on territorial. And then they simply say, do you understand the charges against you? And the word understand means understand, under their standing. Yes. Well, I've perfected jurisdiction. Then they say, how do you plead? We are not taught that there is a concept from the very, very beginning that says, I plead demurrer. And demurrer simply means to cease fighting, to hold the adversarial contest until a matter of law is resolved. And the matter of law that we wish to resolve is, hopefully, we haven't simply agreed ourselves to be in their jurisdiction.
Oh.
And if they've ramroded us through, we would like the jurisdiction matter to be tested. So you don't just simply have to say guilty or not guilty.
How do you spell demur? Demur?
D-E-M-U-R-R-E-R, demurrer.
And that means what?
To halt proceedings until a matter of law, until an interlocutory matter has been resolved.
So if one has a birth certificate and then repeats that name in a court, that's other than the best thing because? Or
if you have a birth certificate, then that is a certificate issued by them, by the registrar acting as the keeper of the rolls. So they are claiming your name as their property, and they're claiming the event of your birth as their property. So if one wishes to challenge their jurisdiction, one needs to prove that you have been registered and that the property is contested. The title of property is contested. So, for example, if you consider the fact that your parents named you, and that if one has a generalized view of spirituality, that no one is your master, we are nobody's slave, then one merely needs to prove that fact in a competing model. And that's always the challenge. People have known what they need to do, but in the absence of a competing model, it's technically impossible to out-argue simply. They say they have a role, they say they're registered, it's in their laws. Unless you have a register, unless you have a higher form of law, they have jurisdiction. And that's how they view it.
So just going into their court and saying where one lives or your name, then it's essentially over as far as one's freedom?
Yep, totally. Anyone that walks in and says, I'm a free man or I'm a sovereign,
right,
I'm a living being, has absolutely no effect. It's water off a duck's back.
So would one, I mean, we're going to the extreme here and just saying if somebody ends up in court, but maybe this is a nice way, then we'll work backwards. So if then one was in there, then the thing to do would be to say nothing and just say that I demur?
Well, then you've got to know, yes, but the only reason you would be able to legitimately claim that is that you have contested their title. You see, personal jurisdiction, territorial and subject matter is an argument of property. The first question is, what is your name? Name comes from Latin nomen, and nomen means the name of the slave, the name of the register, the slave roll. So they are establishing in that one question that you are on the roll, and if you're on the roll, then you are the property of the state.
Wow.
So unless you contest that property issue, the next two questions are just going to perfect that jurisdiction.
How would one contest that issue if they say, are you Franco Collins?
Well, you would have to go to the extent over years and years and years of contesting things like their canon law, their codes of law, creating a higher register, and creating a site that looks similar to One Heaven.
Oh, in other words, that's why you've done this work to establish that you're not Franco Collins, but you're a spiritual being that just happens to be in a body that somebody called Franco Collins?
That's right. I'm a trust recipient number, etc., 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 on a higher roll. Look, if the system recognised what people have been saying for a lot longer than I have been around this earth in this particular version, then you wouldn't need the site One Heaven. You wouldn't need Katie. You wouldn't need any of it because folks already know who they are.
Right.
The problem they've been facing is you can't consume a bad idea by walking away from the field. You've got two choices. Either you play their game, which is in their minds a way of them learning. That's why they love contests, because that's how they fix things. Or you do what they've done to us over the centuries. You consume them. But you can't compete by simply saying, I am a spiritual being, I'm a divine being. Because they've trained their people at the front line to say, if it looks like a duck, walks like a duck, acts like a duck, it's a duck. So unless you have a society with law, with a higher claim, you're not going to get anywhere.